Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about the limits on police searches and a new case heading to the Supreme Court of Canada. The case involves a vehicle that was parked on a private driveway while running. Calls had been made about a suspected impaired driver in a vehicle matching its description, but when police found the car on the private driveway, could they enter the property to investigate? In this case, R and Singer, they did. They entered the property, peered into the car windows, opened the door, and woke up a man who was inside and charged him with impaired driving. Now, impaired driving is a serious social ill and a criminal offense. But could the police enter his property and search his car without a warrant? The Crown has claimed they have an implied license to enter property to communicate with the property owner. But in this case, they did more than communicate, they collected evidence. Can that evidence be used to charge this man, Singer, with a crime? That's what the Supreme Court will be considering in this case originating from Saskatchewan. And the charity that I work for, the Canadian Constitution Foundation, will be intervening. We're represented by lawyer Anna Maria Enenajor, who joins us today to discuss the case. Anna Maria, thank you so much for joining us today. As I explained, the case uh, involves the sort of scope of police power to search, and I laid out the background facts. But is there anything else about those facts in the background here that you think is important to know?
Well, I think you've laid it out pretty clearly and correctly. The only thing I would add is that before the police entered Mr. Singer's property, they did not have what we in the legal community like to call RPG, which stands for reasonable and probable grounds, and that is a threshold that police have to meet in order to rebut the presumption of excluding the state from your property through the search powers. So they
Hmm.
didn't have reasonable and probable grounds to believe that Mr. Singer had committed an offense or that any evidence of an offense would be available on his property once they cross the threshold. So that's the only nuance that I would add.
Now, one of the things that's interesting about this case is there was this report of a vehicle matching its description. Some of the commentary around this case has suggested the police could have gotten what's called a telewarrant. Maybe you could tell us how easy it is or how hard it is to obtain a warrant in circumstances like this.
Well, it really depends on the jurisdiction that you're in, but telewarrants are designed specifically for this kind of situation where you have an individual who, or a police, excuse me, we have police who are either witnessing or seeing something in action, but they don't have sufficient grounds to enter a property or to arrest someone immediately, but they think that there could be something that would be fruitful from a search. They still have to establish reasonable probable grounds, and then they could call in an application to get a warrant, and that can be done in as little as a few 30 minutes to a few hours.
Hmm. So, in this case, maybe you could tell us a little bit about what happened at the lower level court, at the trial level, and then at the Court of Appeal.
Certainly. So at the trial level, the trial judge found that Mr. Singer's counsel had been arguing that the entry into his property, so from the moment that the police crossed the threshold from the public sidewalk onto his private driveway, that constituted a search. It is an entry into a person's private property, and therefore all the subsequent actions that the police undertook were unconstitutional. So you had to throw out all of the evidence that they found, including the evidence that they noticed on his person, which is they smelled his breath, they observed his eyes and his state of being, essentially. And the trial judge found against them on that argument. He found that the police entry onto the driveway did not amount to a search because he didn't have a reasonable expectation of privacy since they were able to view his vehicle from the road, and he was able. Then they were able to. They had an implied license, effectively, to enter his property to affect the actions that they took. Now, the Court of Appeal, on the other hand, found that that was not the case. They overturned the trial judge's decision, and the Court of Appeal of Saskatchewan found that there was a breach of his right to be free from unreasonable search and seizure, and they excluded the evidence that the police uncovered in that case as a result. And because there was no evidence in the investigation, once the evidence that the police had observed was excluded, he was ultimately convicted of that offense.
Mhm.
acquitted of that offense.
So, a lot of this case is going to turn on this notion of an implied license, and that's what we at the CCF will be intervening on. When we come back from commercial break, I want to discuss that with you. We'll be right back. Welcome back to Canadian Justice, where we're discussing the scope of police powers to enter private property without a warrant, look into the window of a vehicle, and collect evidence. Those are the facts of a case heading to the Supreme Court called R and Singer. Now, in this case, Anna Maria, the police have claimed that they have what's called an implied license to enter the property. What is an implied license and how does it work?
So, an implied license is a concept that we've integrated into Canadian constitutional law, but it emanates from common law. This principle that a man's home is his castle, and without permission to enter onto one's property, you are trespassing. And so, the implied license doctrine says is kind of like a carve out of that general principle. And what it means is that, yes, you need permission to enter a person's property, otherwise, it's trespass. But there are a few exceptions, including approaching the property for the purpose of communicating with an individual. So think about the mailman coming up to your front door and dropping stuff off at your door. He has crossed the threshold onto your property, but as a society, there are social norms that deem that acceptable. He has an implied license to do that. So also, the police have an implied license to go up to your property and knock on the door and ask you something. That does not constitute a search that violates Section 8 of the Constitution. Rather, we as a society accept that the police can approach you, can cross the threshold of the property for the purpose of communicating. When it exceeds the purpose of communicating, then it transitions to, then it goes beyond implied license, and it is in fact a search, and you do have a reasonable expectation of privacy at that moment.
So it's really interesting because of course I want my Amazon delivery driver to be able to drop off packages at my door, but I think that this notion of an implied license really needs to be carefully circumscribed when it comes to the court. And the idea that the police could enter the property to communicate with me, sure, but in this case they did more. They looked in the window of the vehicle, they opened the vehicle door, they touched the person inside, and they collected evidence. That seems to be going beyond just communicating with him. What do you think of that?
Yes, absolutely. And on behalf of the Canadian Constitutional Foundation, what we're attempting to argue, or what we'd be asking the court to recognize, is that the implied license is restrictive. It is a narrow scope exception to the broad principle that a person that is crossing onto your property is trespassing unless you have given them permission. So, what are some of the exceptions to that principle? Well, you'd have to look at and in what conditions, in what context a person would otherwise consent to somebody crossing over their property. So as you mentioned, Christine, an Amazon driver, sure, you would consent to him entering your property and dropping off a package on your front door, but you don't want him then opening your garage door. You don't want him, if you have an outside safe or a shed, rattling the keys to see if it's unlocked and opening that. That all is beyond the threshold of what we consider acceptable as a society because of the primacy of privacy that we have, and not just personal privacy, but territorial privacy,
Mhm.
privacy over one's property.
Yeah,
And
and
so
in fact, if someone was doing that on my property, I would probably call the police.
exactly. And our rules apply equally to the police as they do with strangers, right? The police are not a special category of people when it comes to trespass. They are still trespassing unless they have an implied license to enter, and the implied license is restricted not just to the purpose, but also the method of the way in which a person attempts to communicate.
Yeah,
So
that's
yes, you can.
important. So
Yeah.
the purpose here could be communicating, not investigating a crime. But what do you mean by method? What's that distinction all about?
So the method is how you go about affecting that purpose. So if you're a police officer and you want to speak to somebody in their home, you have you formed a subjective intent in your mind to communicate with them. There we have established the purpose. Then the next question is, how are you going about doing it? You may wish to communicate the person. That does not entitle you to open locked doors, to peek under tarps, to open trunks of cars, to ask somebody to take off their clothes. Those are all methods that are improper and impermissible. So it's not just the purpose, but the purpose also has to be circumscribed by the methods used, and those have to be reasonable.
Really important because, of course, our right to privacy, that we do have that protected in the charter by Section 8 of the charter, which guarantees the right to be free from an unreasonable search and seizure. We've got to go to break now, but we are going to be right back. Welcome back to Canadian Justice, where we're discussing a case headed to the Supreme Court about the scope of police search powers. The case is called R.N. Singer, and it involves police who entered the private property of a man, and they found him in his vehicle unconscious. They looked in the windows and opened the vehicle door without a warrant. Is that an unreasonable search under the charter? Now, the charter does guarantee the right to be free from an unreasonable search, but it does have that preface, the word reasonable. So, Anna Maria, what makes a search reasonable or unreasonable, and how might it apply in this case?
So before I go to that question, the issue in Singer actually precedes the inquiry of whether or not the search is reasonable or unreasonable, because the Crown and the police are arguing that there isn't even a search in this case to be determined to be unreasonable. They're saying that no search exists because there's an implied license for the police to do exactly what they did, and as a result, they're saying that the other inquiry, which is the where most of the work is usually done in these kinds of search and seizure cases, the determination of reasonableness is not even required in this case. But once we've determined that a search has taken place, then the question is whether or not it's reasonable. And the Supreme Court is clear that all searches that are warrantless, so unless a warrant is granted, are unreasonable. So you have to have a warrant in order for a search to be reasonable, but there are some exceptions. For example, the exigent circumstances doctrine, where you see somebody, classic example with a bloody knife running into a building that's locked. The police can go into that building because there are exigent circumstances. There may be someone's life at risk. So there are small exceptions. And also there's the ancillary powers doctrine, which recognizes sort of powers that emanate from the police's authority to enforce the law and to investigate. But again, those have to be circumscribed because they are exceptions. So the gold standard in Canada for whether a search is reasonable or not is, was it conducted pursuant to a warrant?
And in this case, it wasn't. So, look, I do think that impaired driving is a serious social problem. It kills people in this country. It's a criminal offense. Police do need to have the powers to investigate impaired driving offenses and charge people with the crime of impaired driving. In this case, that's what Mr. Singer was charged with. What could the police have done differently in this case to investigate their crime? Could they have obtained a warrant? What should they have done in these circumstances rather than relying on this implied license to enter his property?
Well, that's an excellent question. And it's one I think that's at the heart of this case because there is very little else that the police could have done, given that they didn't form reasonable and probable grounds to believe that this person whose property rights they are violating has committed any crime. They had some suspicion, but it didn't amount to enough. And the Supreme Court of Canada has told us that that nature of suspicion is not enough to trump an individual's liberties, particularly when it comes to their own personal privacy. When it comes to impaired driving, our laws have recognized that this is a scourge on society. And so a lot of the Highway Traffic Act laws and criminal code laws give police powers to search not only a person's car, but their bodily fluids where they have suspicion of criminal offenses. So the powers that police have generally to investigate impaired driving are much broader than in other contexts. But in this context, the police had nothing more than suspicion, and we don't accept suspicion as a grounds to do anything when it comes to searches.
Now, there is some existing case law on this implied license that the Crown is relying on here. What does the existing case law tell us?
Well, some of the existing case law, I think you're referring to a case coming out, case from the Court of Appeal of Ontario, and in that case, the police recognized that there was or the court recognized that there was an implied license to search in very similar circumstances as the one that is before the court. However, the police had a stronger reason to believe that a crime was taking place. Had taken place. And so, in that circumstance, it's not just the facts that are parallel, but we have to look at what the distinguishing features of each of the facts are. And in that case, the police had a lot more to go on than merely a person with their car running in their driveway.
Yeah, suspicion just isn't good enough in a case like this.
Yeah.
We've got to go to commercial break now, Anna Maria. But when we come back, I want to talk about what other jurisdictions, yeah, how other jurisdictions like the United States treat this implied license. We'll be right back. Welcome back to Canadian Justice, where we're discussing the scope of police powers to conduct searches and enter private property, and this notion that there's an implied license that anyone can come onto your property for the purposes of communicating with you. Now, this is a concept that exists in Canada. Anna Maria, how do other jurisdictions like the United States think about things like privacy and the implied license? Is there anything we can learn from their case law?
We absolutely can learn from their case law. The most important case in Canada that defines the test or the method of analyzing whether there is an unreasonable search and seizure is a case called Hunter and Southam, in which the court attempted to broaden the scope of Section 8's ability to protect beyond just property rights to the right to privacy. Since then, some of the language that was originally in that decision has fallen to the wayside, and most courts now focus primarily on considering freedom from unreasonable search and seizure to revolve around this concept of privacy and exclusively privacy. In the United States, they've had similar threads in the development of their case law and their jurisprudence, where there's a primary consideration in relation to search and seizure around the protecting property, but also an evolution of that case law to look at protecting privacy as well. But in the United States, the courts have been very clear about continuing to recognize property as a standalone head of protecting an individual against the search and seizure of a state. So it's not just there whether they have a reasonable expectation of privacy, which is a very nuanced calculus that depends on a number of factors and is very contextual, but also just the fact of private property itself is sufficient to trigger the protection of the freedom from unreasonable search and seizure. We have yet to have a definitive pronouncement of that principle in Canada. In Hunter and Southam, the case that I referenced earlier, the Supreme Court does say that the Section 8, the section of the Charter that protects people from unreasonable search and seizure, protects people beyond just their private property. Like if you think about, bodily integrity or the search of their digital devices or their online private presence. Those are very important concepts to keep in mind. However, we seem to have lost the plot a little bit on what role private property plays in entrenching one's right to be free from unreasonable search and seizure.
Now, there's different types of property. So I'm kind of curious how this might play out in different scenarios. So in this case, Mr. Singer was in his vehicle, which was on his property. So how might it be different if, for example, police looked inside the window of his house instead of the window of his vehicle? Or alternatively, if his car was not parked on his private driveway, it was parked on a public street and the police looked in the vehicle window. How might these expectations of privacy in these different scenarios play out?
Yeah, absolutely. So, the test for determining the degree of protection or the strength of protection that Section 8 affords to individuals in relation does relate to the nature of the property, their relationship with the property, and whether the property has the tendency to reveal something about their biographical core. So even though things like a cell phone could be on the street, if a police sees the cell phone, they need to get a separate search warrant to access the information inside, because we've recognized that that information is so central and sacred to our individual privacy. If the individual if the police were looking through a house window, we have recognized in our jurisprudence that the home is one of the most sacred spaces for protection of privacy. And again, this goes back to the top of our discussion where I mentioned that the sort of maxim that a man's home is his castle, and we've really integrated that into our law, but through the concept of this reasonable expectation of privacy analysis. And in that analysis tells us that for things like our bodily fluids, for example, or our home, our intimate drawers in our home, our intimate computers, our personal devices, there's a greater expectation of privacy in those items.
Interesting. I mean, I think you can tell a lot about me by looking in my car window, namely that I have destructive small children. But that's a different issue. Anna Maria, thank you so much for joining today and explaining this case.
It was my great pleasure, Christine.
We've heard today about the case of Aaron Singer headed to the Supreme Court. Did the police go too far in this case? How would you feel if someone entered your driveway and looked into the windows of your car or home? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.